We are ready to call to order the 184th meeting of the Massachusetts Gaming Commission at 101 Federal Street at 10 o'clock on March 24th. Our first and principal item of business is led off by our Ombudsman, Mr. Ziemba.
Good morning, Mr. Chairman, Commissioners. Commissioners, today we'll hear from representatives from Mass Gaming and Entertainment in response to the presentation the Commission received on March 15, 2016 regarding the planned Wampanoag Tribal Casino in Taunton. The Commission has repeatedly noted that information regarding the proposed Taunton facility would be important to its evaluation process in Region C. Information provided by MGNE today will also be an important part of the Commission's Region C evaluation. To put this in context, the Commission, as the Commission is fully aware, the Commission's current plan and policy, a policy it has applied in all licensing decisions thus far, is that it will make a determination on whether to issue a license only after its review of the full gaming application, and then only if its review shows that issuance of a license would be beneficial to the Commonwealth given the totality of the then existing and foreseeable economic circumstances. For the Region C review, this totality would include the potential for competition by a tribal casino. Our review process will include a careful evaluation of the status of competition in the region and the impact a commercial facility would have in the region and in the Commonwealth. Following today's presentation, the Commission plans to conclude the host community hearing in Brockton on Monday, March 28th. Members of the public and interested parties are invited to provide the Commission with the opportunity to hear any comments related to events occurring since the opening of this host community hearing on March 1st. Such new events would include, but not be limited to, today's meeting and the information presented at today's meeting. I note that those wishing to provide comment may also do so in writing to the Commission by sending an email to mgccomments@state.ma.us with MGNE Brockton in the subject line. All comments received via email will be made public and distributed to the Commission for its review. In regard to the public hearing, I note that we did receive materials over the last couple of days from the MGNE team, and it is likely that the Commission has not been able to fully evaluate all of those filings, so the Commission may ask a number of questions today of the panel, but it's likely that questions may spring into Monday as well. With that as a context, I welcome John Donnelly of Donnelly Clark and Mr. Neil Bloom, Chairman of Rush Street Gaming, to introduce the panel today and to begin their presentation.
Good morning. Thank you. John Donnelly, Donnelly and Clark. Thank you for the opportunity to present again today, and we plan today to respond to some recent issues that have been, or some recent comments that have been made regarding our project, to bring the Commission up to date on the current status of the project, and to introduce some new ideas, notions, and findings that we've discovered in the course of this process. Today, speaking to you will be people you've met before, but we promise not to retread old ground. Number one will be, the speaker will be David Tennant, who is the head, or the co-chair of the Indian Gaming Law and Gaming practice of Nixon Peabody, and also, I think kind of importantly, the head of its appellate practice. And Nixon Peabody, as you know, is a large firm which has an office large office in Boston. Second with me, right next to me, is Michael Soul, the president of the Innovation Group. And let me go back to David. David sent one of those letters that's before the Commission. The Innovation Group also submitted some information to you. The Innovation Group's appeared many times before you in the past, and I'll take an opportunity to give you some of their credentials, because I know Michael and his predecessor, and I've used them in other presentations as experts in other matters. But there's been a lot of talk about the gravity model. And everyone in this room is familiar with it because it's every time you're in the Gaming Commission it's discussed. It was the Innovation Group that didn't invent the model itself, but were the first group to take that model and apply it to gaming. I've heard Michael's predecessor talk about it on many occasions. They took the gravity model, which was a transportation model, and applied it to gaming to analyze and project forward what kind of revenues could be expected in a certain area or region. So to the extent that others are presenting gravity models, they're standing on the shoulders of what the innovation group innovated, if you will. They've represented a number of governmental agencies and private entities, and importantly, they've represented over 100 Indian tribes, and continue to do so as well as other foreign nations. Finally, Neil Bloom, who's presented to you many times, becoming a citizen here, I think, and Neil's the chairman of Rush Street Gaming, which is the parent company of all the entities that operate gaming in the United States, and the parent of Mass Gaming and Entertainment. At the end of the presentation by these three presenters, we plan to cede some time to Adam Bond, who's also in the room, who's a Middleborough attorney and who represents the citizens group that has filed the litigation regarding the land and trust issue and other issues. And Adam will present at the end of the three presenters I've introduced. With that, I will call David Tennant.
Good morning, Chairman Crosby and fellow commissioners.
Good morning.
Good morning.
Thank you for the opportunity to speak to you this morning. What I would like to do with the time that I have is to address 4 points, to briefly touch on some of the comments about the Commission's authority to issue a license in Region C. I'd like to spend some time talking about the new development as far as the second compact not being a legally effective and valid agreement. The third point would be to talk about the Carcieri issue and the comments that the outside counsel for the Mashpees made at the March 15 hearing. And then finally to talk about the different timelines that attach, one to the citizens lawsuit in federal court that's already been filed, and then any type of legal action that the Mashpees might take against the commission. And as we indicated in our letter, those are very, very different timelines, and any type of quid pro quo that the tribe is thinking that they can jam up this proceeding with that type of legal action, they're not comparable. But we'll address these in turn. So I'd like to start briefly with the Commission's authority to act. Obviously, there was a very careful analysis by Commissioner McHugh in December of 2012. That was at a critical time after two significant events. One was the First Circuit's decision in KG Urban, which said very clearly that there could not be any type of prolonged set-aside, that there could not be, from a constitutional perspective, anything beyond some type of, as the Commission used the wording of a fair shot or a leg up, that had to be a limited, time-limited type of advantage. And then, of course, there was, that decision was in August of 2012. The Secretary of the Interior then in October of 2012 disapproved, thoroughly repudiated the first compact. And those two events clearly signaled to Commissioner McHugh and the other members of the Commission that there was a real problem with events, with the developments in Region C, and exactly the type of prolonged delays could occur, that the tight deadlines in the statute, the Expanded Gaming Act 91E, those were going to be blown by, and certainly from I think a strict reading of 91E, that you would have the straight triggering authority to go ahead and issue the RFA in April of 2013 because of the failure to actually have a compact in place. That first compact was a complete legal nullity. So even though it had been legislatively approved in Massachusetts in July of 2012, it never took effect. So from the standpoint of really straight up reading of 91E, I think the triggering authority was there as a straight up matter, even if it wasn't, for whatever reasons, exactly precisely triggered. The Commission clearly had the discretionary authority to act at that time for all of the reasons that Commissioner McHugh indicated, and obviously the Commission has consistently and thoroughly, restated and said that this authority exists. And really, I don't think there's any need to replow that authority. It's spelled out in our letter. The issue is fully framed. The one thing I would like to talk about, though, is the Mashpee's heavy reliance on Part 2.6, which is part of the compact that is easily dispensed with for any number of reasons, setting aside for the moment that the compact itself is entirely of no validity. Part 2.6 is within Part 2, which says this is offered for background only. So it's not even a substantive provision. And then there are, as we indicated in our letter, a number of reasons why it just doesn't work the way the MASH-P say Part 2.6 works. For one, it adds language that isn't present in 91E. If it was supposed to be a fair transcription, which that is what the compact says, it's just saying here, this is what 91E says. It's not even purporting to change. It just says we're incorporating 91E into the compact, and it does so inaccurately. It puts in express prohibitory language that you don't see in 91E. So it's just a wrong transcription. And then to the extent that there was any validity to that part anyway, you can't have by an executive contract that isn't part of a session law, that doesn't go through the House and all the formal procedures. You can't just have an executive contract that gets legislatively approved, trumping, overruling, and add all kinds of terms to 91E. And of course, there was not any type of process followed within the legislature to modify or amend 91E at the time that the compact was approved. And again, there's even another layer of why 2.6 is no barrier, because 2.6 only talks about the reference to the RFA issuing as a trigger, and that to the extent there even was any type of limitation on the RFA triggering, I mean, this commission dealt with this back in April 2013. Here it is in 2016, 3 years later, and clearly has the authority to move past any type of limitation that existed at the time. If I could now just go straight into the validity of the compact. We've laid out in our letter precisely why we believe the compact is of absolutely no legal effect by its own terms. And if I could point you to page 12 of our letter, I'll just quote what is the provision within the compact that makes this second compact invalid as a matter of law. Reading it, quoting it, "This compact shall become effective upon the publication of notice of approval by the United States Secretary of the Interior in the Federal Register in accordance with 25 U.S.C. sections 2710 little d 3 big B and 2710 little d 8 big D." And there are various statutory sections at play here, and I think the easiest way to refer to them are by the last letters. There's a big B and a big D referenced in Part 22. What is significant is that a big C is not present there. And I'm going to try to help the Commission by walking through what is the distinction between these different statutory provisions regarding the Secretary acting on compacts that are submitted to it for approval. There are basically two critically different paths that the Secretary of the Interior can follow. It can issue what is called a notice of approval, that is a full-on approval, and that is under the big B authority. That is something that has to happen within the 45-day review period that the Secretary has. And as we've indicated by quoting the Assistant Secretary in his testimony in 2014 before the Senate committee, having the Secretary actually formally, officially, affirmatively approve a compact within that 45-day review period has significant legal consequences. It means the Secretary is vouching for the compact, that it's legal under IGRA and other federal laws. It carries with it necessarily the Secretarial's findings in that regard, and if you were to have any challenge in a court over the enforceability of the compact, a secretarially officially, affirmatively endorsed compact vouched for under this provision, where it is published as a notice of approval in the Federal Register under the Big B, that carries with it all of the findings that we've talked about. Chevron deference, you've heard about that from the Mashpee's outside counsel in terms of the deference that would be showed to the Secretary with respect to the record of decision to take land into trust. Well, it's a universal principle of reviewing agency determinations at the federal level, and that deference would attach to the Secretary's formal finding that the compact satisfies IGRA and other federal laws. We cite a case where it wasn't necessarily even clear what a court could do if they didn't have that type of finding. So let's talk about the alternative decision path. What could happen outside of that 45-day review period? And that's exactly what happened here. It's a totally different decision path. The Secretary said, here, I'm not going to make any decision. This is a hands-off. There are problems with it. I'm not going to disapprove it again because we don't like to disapprove these things, but I'm going to punt it. I'm going to kick it back to the parties and the courts to determine whether this is an enforceable agreement. It's a fundamentally different kind of authority that is coming from the Secretary. In fact, it's no authority at all other than it's deemed approved by operation of law. When the Secretary does nothing, it's deemed approved to the extent it is consistent with IGRA. So it's not any type of finding whatsoever that it actually satisfies IGRA. And you wind up with, instead of the secretarial findings that get judicially deferred to, you have a complete open book, and it would be up to the parties and the courts to figure out what does this document mean. And why this is significant. I mean, you've heard the Mashpees talk about the compact being an historical document, that it's something that is reflecting the long history of the peoples and the Commonwealth and coming together. If you're having a major public compact that is being legislatively approved in Massachusetts, and the governor is signing it here, the parties sure want to have this historical document bearing the formal, official, affirmative seal of approval of the Secretary vouching for its legality, and not to have all that effort squandered and put into this highly inferior category where it just kicked back to the parties, in the words of the Secretary, punted back to the parties for them to figure out whether it's legal or not. This is clearly, the parties here specifically called out the approval process that is the formal official seal of approval, vouched for, and publication as a notice of approval in the Federal Register. What they got instead was this no action within the 45-day period, no statement of approval, and instead a notice of taking effect. A notice of taking effect is the big C option in the statute, and that just says, as I've indicated, that it doesn't have any force of findings of the Secretary. It is only taking effect by operation of law, subject to the parties figuring out whether it is lawfully enforced or not. So it's a highly, highly, highly diminished, deemed approved secretarial inaction. It's not what the parties bargained for, and it was clearly a very important consideration. It was present in both the first compact and the second compact, and was what the parties necessarily wanted to have, reflected their intentions to have a formal endorsement by the Secretary. For a critical document like this, with all of its public and political implications, the last thing you want is the Secretary basically punting on it and saying, well, hey, you figure it out. There's an awful lot that is riding on the compact, and the parties understood that, and it was up to the parties to secure from the Secretary the formal official vouched for notice of approval, and they didn't get it. So under Part 22, the compact never took effect. by its own terms. The only way the compact could ever take legal effect was upon the publication of the notice of approval. So that leaves the proceedings here in a potentially different light. Obviously, for purposes of the narrow question of the arguments that the Mashpees have raised about the Commission's authority, the compact disappears entirely. It has no valid force or effect, and all those arguments, which weren't winning anyway, those disappear. But the bigger question, of course, is what does it mean to have now a proposed tribal casino in Taunton that doesn't have, in 2016, the basic essential building block of a state tribal gaming compact. From our perspective, it certainly puts the tribal casino into a highly doubtful category. We're talking about it's already resting on an infirm foundation with the land into trust decision for all the reasons we've indicated, and I'll address that in a little bit. I mean, that's one necessary leg of a stool that is totally infirm, and now the compact, which is an essential component that everybody thought was in place, isn't in place. And what does that mean? I mean, we're talking about having to renegotiate. The Mashpees and the governor have to renegotiate the compact. Well, is there even the political will to do that? We have a new governor. There's a new legislature. What would be the terms that would change? Would that be acceptable? Could they even get the secretary with another go-round to get the formal approval that is obviously excellent policy? You want that? Would it make sense for the legislature and the governor just to say, oh, we don't need that type of formal official vouching from the secretary? We'll take our chances with a deemed approved compact? I mean, that's a political question, but we're raising these because these are important questions. We don't have answers. Obviously, the parties to the compact, we're not parties to the compact. The commission isn't a party to the compact. But it clearly has significant implications that adds to the clouds, the doubts, the questions about the ability of the Mashpees to ever do anything with a tribal casino in Taunton. They can't operate a casino without a state tribal compact that authorizes them to do Class 3 gaming under IGRA, which is the casino type of table games and slots. They can't do, that's the whole point of having the Taunton casino, and they can't do it without the state tribal gaming compact. So that's kind of the new development. Certainly, I'll move on to my other comments, but I want to give the commission an opportunity since this is new.
Yeah, before you do, I have a couple of questions. One in particular on this issue of the apparent failure by the secretary to formally approve. But just to make an observation with regard to your the first topic, namely the power of the commission to proceed with the Region C. I think, and I'm just speaking personally here, obviously, but I think you're entirely right on that. I've reviewed the compact, the statute, and the prior statements of my predecessor, and I've said any number of times, I am no Jim McHugh, but I think that his analysis was completely on point, and so I have no issues with regard to that. But the second argument that you just made on the issue of the approval by the secretary, it strikes me, and this is not a reflection on your position, it's kind of a gotcha situation, that it was that kind of regardless of what the language of the compact was, everybody has proceeded until we received this recent, filing by MG&E on the assumption that the compact was a valid compact. I hear you saying that by virtue of the failure of the secretary to have affirmatively endorsed it, that it's in a kind of a second-rate status, but there appears to be no question but that the secretary and thereafter proceeded on the assumption that it was a valid compact, and the assumption upon which the record of decision of the Secretary that concluded with the land and trust decision by the department was that there was a valid compact. So if that's a matter of record, isn't that sufficient? Alternatively, is there not a ready fix here by the Secretary?
Well, let me address the last part in terms of, is this readily fixed? I mean, if you view this as not a type of technical failing on the part of the Secretary, but there are these fundamentally two decision paths, and the parties bargained for one specific decision path, and they got the other. Obviously, parties can act without having an enforceable agreement. A private party in contract can just say, well, we don't care whether it's enforceable, whether an express condition precedent occurred, and that's what this is. The Part 22 requiring the notice of publication of approval, that's an express condition precedent, so under the law, straight up, it didn't take effect. Could the parties just basically act outside of contract? Could they just pretend, basically adopt it and be bound by estoppel principles? I would never advise one of our clients to do that. And when you're talking about public entities, this is the governor, it's the Commonwealth, it's the whole political process here that really wanted to have a compact that had the Secretarial's approval that befitted its historical nature, and they put that into the compact, that it's up to the parties. It's really not up to the Secretary. The Secretary can't do anything to change the terms of the compact. The parties can change the compact and try to get the Secretary to approve it. But there isn't anything from the standpoint the Secretary couldn't pull back the decision and say, oh, I really meant to give it formal approval, because the Secretary sent along a letter saying why the Secretary didn't feel it was a compact that the Secretary could approve. There were deficiencies. There were aspects of it that gave the Secretary serious pause about whether those terms were enforceable under IGRA. And the Secretary specifically said, I'm not going to approve this in light of those concerns. Now, could those stated concerns be addressed, and could the parties renegotiate, and could they represent it to the governor, and could the legislature do that? Sure, but is there political will? How long would that take? And I don't believe there's any secretarial fix that can be done. And in terms of a gotcha, just in terms of how this came up from our end, I have been focused on the record of decision, challenging that. The compact was always at the periphery in terms of the legal issues that we were looking at. It was only in response to the MASHP's heavy reliance on Part 2.6, where, they're basically writing that as hard as they can, as far as they can, that I really went back to the compact and looked through all of its provisions, and then we identified the Part 22 as being an express condition precedent that, the Secretary never issued the kind of approval that was required by the parties, and that this isn't some type of, oh, gee, it's a fair equivalent. It's a fundamentally different kind of action by the Secretary. It's inaction, deemed approved, and then gets tossed back, in the words of the Secretary, punted back to the parties and the courts, because the Secretary isn't standing behind it. So I obviously, it's for others, the parties to the compact and their lawyers, but as a matter of public policy, I would think that the Commonwealth, the governor, people who are representing the people of the Commonwealth of Massachusetts would want to have a state tribal gaming compact officially approved by the secretary and not kicked back.
Anybody else? I can't, this is new to us, and we'll be thinking about it, and there may be other folks who end up being the resolvers of it, but I certainly understand, and that seems substantive and interesting, the distinction between the two kinds of approval. I mean, you make the clear points that make sense on that, but whether, and that seems substantive, but whether the drafter of the compact, in a sort of like Commissioner McDonald is saying, inadvertently neglected to mention the two possibilities of approval. It's hard to believe that the drafters of the compact would have thought that they wouldn't consider the compact approved if it had been approved by this passage of law as opposed to the notice of approval. Section 2.6 is clear evidence that the drafters of the compact weren't totally buttoned up. You know, we agree with you completely that 2.6 flat out misconstrues what 91E says, baldly. And it seems like maybe it was the same kind of inadvertence, but so to harp on the distinction between the kinds of approval as a substantive difference, that's real. Whether the failure of the compact to acknowledge this sort of technical other alternative approval, whether that's substantive or not, I have a real question.
If I could just make one comment on that. Certainly, if we were advising any of our clients in this area, we would always say, get the secretarial approval, because it has all of the, it's not just belts and suspenders, it's the essential secretarial finding that keeps you out of being, you're basically in a purgatory where it's kicked back to you and you don't know what you have until there's a lawsuit. And parties intentionally and knowingly agree to do that, to get that secretarial approval. And I think the fair reading is whatever draftsmanship problems there are in the compact, that they intentionally not only stated that a notice of approval had to be provided by the secretary for the compact to become effective, but they did not cite, they omitted any reference to the alternative of notice of taking effect, which is very different verbiage, and they omitted the actual underlying statute, the big C statute that provides for the notice of taking effect. So I think the logical analysis would be, and obviously the parties could, they were represented, I believe, by able counsel, and I believe, the record would show that they fully understood and knew exactly what they were bargaining for by putting in, we're getting secretarial formal official approval, notice of approval, and leaving out of the compact this other lesser form.
But Mr. Tennant, help me understand, who would have standing and an interest to sue besides the parties, besides the Commonwealth and the Mashpee, on the validity of the compact?
Well, an excellent question. And I don't know what in the standing rules in the state of, or the Commonwealth of Massachusetts, but citizens, I would imagine, who are impacted by this. It's not a remote type of injury if they are being impacted by it. So I would think that there are essentially intended third-party beneficiaries, people who are, just from the biggest picture perspective, this was supposed to be this historical agreement that was bringing together the Commonwealth and the Mashpees, and for the benefit of the people of the Commonwealth. This was a big deal. And I would think that anybody who was supposed to benefit from that, and I think that's the people of the Commonwealth, that they would certainly have a right to complain. And again, I'm not vouching on the standing issues under Massachusetts law. I'm not a Massachusetts lawyer.
Attorney, in looking at the material you provided, give me an idea in a broader context of how often this action, or in this case, any action by the Secretary, has been used most recently.
About 22% of the time, I think, is what the Secretary in his comments to the Congress indicated that they really don't like to disapprove. That indicates just how bad the first compact was. They will let fly, let go by inaction a lot of stuff. So when the first compact got rejected, disapproved, that was a thorough repudiation of all of its terms. But they let the compacts go, whatever, about a quarter of the time.
We have the Secretary's letter that accompanied the approval by passage of law.
The record of decision?
No, not the record of decision. Well, I don't know if it's in the record of decision. No, not the record of decision. The
Deemed approved.
the task, the deemed approval of the compact. You referred to a
Right, it's a
Secretary's
notice
letter.
of taking effect that was issued January 20-something and took effect February 3rd of
And you
2014.
referred to a Secretary's letter that accompanied that.
Right. It was published in the Federal Register. What the Secretary typically does. not all-
Hang on, just,
Yeah.
do we have that? Do
We either have it or we can
Or we
find
can
it.
get
It
it,
was,
okay, yeah,
I mean,
yeah.
it would have been a public notice.
Okay.
We do certainly have the letter from the Secretary where they disapproved the first compact,
Right.
which is quite detailed.
Right, and we can get the other one, right, okay. Anything else on this one?
Well, just following up a little bit, just to clarify my understanding of it, that the requirement of a compact, what's the origin of that? Is it in the Indian Gaming Regulatory Act?
Yes.
So that as a condition of a tribe being permitted to have a gaming license pursuant to a land and trust decision, there must be a compact that has been entered into by the state and the tribe?
Correct. For Class 3 gaming.
For what we think of as traditional casino gaming, but
Casino
they have a
gaming.
right to do so-called Indian gaming without a compact, which,
Correct.
to many people, Indian gaming is indistinguishable from what we refer to as casino gaming. So they don't need a compact. They can do a casino in Taunton with or without a compact,
Well,
but it limits the nature of the gaming
It
that they can do
substantially
within the
limits. I
compact.
mean, it's really bingo style, and there are variations of slots that have been conformed to basically have a bingo-type internal operation, but it fundamentally limits what they can do, and it completely changes their whole business plan. The whole reason to build this casino initially as a full resort casino, I mean, you've obviously heard how it's been scaled back, but even in the scaled-back version, it's supposed to be a full casino offering table games, roulette, baccarat, slots, the whole
Right.
9 yards.
But it is a requirement of the Indian Gaming Regulatory Act, the enforcement of which comes within the jurisdiction of the Department of the Interior,
That's correct.
and that the Secretary, through its record of decision, voluminous record of decision, and I guess you're going to be addressing that shortly, but the Secretary, did the Secretary, in your mind, give expression either in the record of decision or in any other form of having doubts about the sufficiency of the compact?
No, and basically, we would say doubts about the sufficiency in terms of, well, we've given it this lesser status. We've punted it, we picked it back. It's effective as a matter of federal law, so it would allow the Mashpees, as a matter of federal law, to meet their IGRA requirements for Class 3. What we're saying is that as a matter of state law, because an express condition precedent that the parties chose, expressly adopted, never occurred, the compact never took effect, and that's not for the Secretary to figure out. That's for some other body to determine.
Anybody else? Okay, next up.
All right. Well, just briefly on Carcieri.
Yeah.
We heard from Arlinda Locklear March 15 in terms of the Carcieri issue and whether it presented a significant hurdle for the Mashpees, and there were questions from Commissioner McDonald in terms of, if now means now, doesn't such mean such? And, basically asking Ms. Locklear if there were any differences between the historical circumstances of the Narragansetts in Rhode Island, who were the subject of the Carcieri decision, and the Mashpees in Massachusetts. Never got anything close to a substantive response. What Mashpees Council has stated before and stated there was the Secretary issued a lengthy decision. The courts will review it deferentially, and basically deference, deference, deference. There's no substantive defense on the merits as to whether the language of the IRA can actually be twisted in the way that the Secretary has done here. There's really been no response on the merits, and it's just back to, well, this is a matter of deference. And we would point out, obviously, in the Carcieri case, there actually was a 70-year history of the courts basically misreading now to mean now or hereafter. And even in that context, with the ability of the parties to point to that practice, the Supreme Court said, no, you just read the IRA the way it's written, and now means now. There isn't a 70-year history of the Secretary misreading the Category 2 definition of Indian. This is fresh, out of the box, unprecedented, new, and it deserves absolutely zero deference, and we believe will receive zero deference in its judicial review, because it represents a rejection of the plain reading of the IRA. And in fact, in the record, but then the Secretary says, well, you can't read it literally because it would render the Class 2 definition of Indian as surplus, would render it meaningless. And that's where we come back with, well, no, not at all. We have the contemporaneous record from Commissioner Collier, the Commissioner of Indian Affairs at the time, and it's basically saying Class 2, Category 2 definition of Indian has a very limited range. It's to collect people who are such members, refers to the members up above in the Category 1, and it just means we're picking up people who aren't enrolled yet in those recognized tribes that are under federal jurisdiction. It would be the children who were too young to actually make it onto the tribal rolls. And there were times when Indians from different reservations would come onto other reservations, and they might join up and be deemed part of the reservation but not reflected on the tribal roll. So this was just a way basically to true up the federal government's records on who was enrolled as a member of a recognized tribe under federal jurisdiction. So it is not, even by the contemporaneous records, any type of larger category, and the suggestion by the Mashpees that it's open-ended and should be deemed to include people who weren't born in 1934, who were under, and then Native Americans who were living on reservations but were under state jurisdiction. That's an open-ended obligation that had nothing to do with what the Secretary was trying to actually do in 1934, which was to define and actually limit, identify for purposes of registering Indians under the IRA. Okay, who's in? Who's in now? And it was an effort to collect, again, just kind of as a catch-all, the children and other members who weren't already registered with the tribes. So it's basically, as we see it, the Mashpees have, they're not the ones defending the record of decision, but they have very great concern that the record of decision will be overturned. It's basically Carcieri 2, with the benefit of Carcieri saying, you read the IRA literally and you don't go into these detours. So we think that, we're going to ultimately prevail on the record of decision. The challenge will succeed, but even if it didn't, it's the kind of challenge that if you've read the citizen's complaint it's a challenge that has a very long horizon, a distant one, and the Carcieri case was over 10 years. I'm not saying this challenge will go that long, but it's certainly by conservative estimate, a 4 to 5 year process, could well go to the Supreme Court again in light of the unprecedented nature of the contentions here by the Secretary. And we really think that, it's, again, ultimately going to come out in our favor many years down the road. If I could just sum up, I mean, there are these serious legal questions about the Mashpee's proposal to go forward with the tribal casino in Taunton. It's not just the infirm foundation of the land and trust decision, which is, palpably, objectionable, and certainly anybody in this room could read the statute and read Carcieri and go, why are we even here? But obviously, the Secretary has staked out a very aggressive position, and it's going to be seriously challenged, and we hope successfully so in the lower court, and if not there, the intermediate court, and if not there, in the Supreme Court. So we have that infirm legal foundation now multiplied by the questions about the gaming compact, and with the, if there is in fact a need to get that renegotiated and back to the governor and the legislature and back to the Secretary, that's a whole other additional layer of delay and uncertainty, because with a change in the who's in the position of governor and the change in the legislature, I certainly don't know whether this is in any way an easy matter and a slam dunk to get it fixed. I think it's fair to say that it's going to take many years for the cloud, and now I think it's multiple clouds that are hanging over the Taunton casino to lift, if ever. And if anything, I think that the issue about the gaming compact not being valid, I mean, you're talking about something that we are 5 years past the enactment of the Expanded Gaming Act, and 4.5 years after the tribe was supposed to have the first compact approved, and that basic component is missing. And so we think that puts kind of an exclamation mark on the question mark that is the tribe's very uncertain prospects in Taunton. Thank you.
Mr. Tennant, but couldn't the tribe continue to build and operate a casino until any one of these courts decides to put an injunction on the project, let's say?
The Mashpees, to the extent
Yep.
that they have the financial resources and the people who are willing to take that kind of risk, sure.
Right.
I have just a further question. As reflected by my questioning of Attorney Locklear at the Mashpee hearing a couple of weeks ago, I have read with interest the Carcieri decision and some other cases raising issues under the land and trust procedure. Again, speaking personally, I think you have a very plausible, position here in light of the kind of categorical nature of the application of the so-called plain meaning rule of statutory construction that the Supreme Court in Carcieri followed. But predicting what the Supreme Court would do under a different set of circumstances is inherently difficult, but here made even more so by the circumstance that this was Justice Thomas's decision was joined by 4 other members of the court, and one of those 4 other members and a very influential member, namely Justice Scalia, has now passed on. So what do you think the impact might be of the uncertainty introduced by the circumstance that that the composition of the highest court in the land to which this issue may very well ultimately be presented has changed materially.
I appreciate, Commissioner McDonald, your comment about Justice Scalia, and obviously, I actually had an opportunity to meet him and to talk to him about the Sherrill versus City of Sherrill versus Oneida case. He is influential, but I would think that the First Circuit, reading the Carcieri decision, would understand that the law is the law and that it doesn't depend upon the current makeup of the Supreme Court. If it gets to the Supreme Court, obviously the composition of the court is very important, and there are members of the court who are more receptive to the, now means now and such means such kind of plain meaning arguments. And I like to think that actually, even if you get past the kind of literal reading and look at the legislative history, and in particular Commissioner Collier's comments, that you're basically back into understanding really what the IRA definition of Indian was intended to do. And you also have, and this is spelled out in the citizen's complaint, there's a whole series of Department of Interior and also Department of Health interpretations of the statutory definition of Indian, and they all go the plain meaning route. So, I mean, there's case law, there are administrative decisions, everybody, and we cite the United States versus John case as a footnote in our latest letter. Basically, anybody who reads the statute who isn't statutorily basically committed to helping the constituent Native American population, anybody who's looking at it objectively is reading it the way we are. And, obviously it will be up to the courts to vindicate our position or to reject it, and, we like our chances.
Okay. Anything else?
You mentioned earlier, a consideration on the question that I asked would be the, higher risk and higher cost of capital, let's say, for proceeding at risk with some uncertainty because of all these reasons. But under that scenario, wouldn't the MASHP have an extra money available were we to award a license on that region, a whole 17% that is now no longer?
I'm going to leave the business modeling and bottom line analysis to others.
Okay.
I'm just a lawyer.
Okay.
I am going to address that in my comments, but before I even get to them, I could say that the actions of Genting, in significantly reducing the amount of money that would be invested in Phase 1 and drastically making that Phase 1 much smaller and less money indicates to me, and it frankly is a rational decision on their part, that they're very nervous that this case will go against them and they'll end up with no casino. And that's why they have said that we are going to, that Phase 1 is financed. They never got into specifics how. Made it clear that Phase 2 and later phases are not yet financed. They hope to get other parties involved. And the size of Phase 1 has been dramatically reduced from what they proposed a few years ago for Phase 1. They actually reduced the amount of gaming positions by 45%. And there's no parking garage. There's less work on infrastructure and traffic. There's no hotel. They were supposed to have 10 retail spots. Now they have one sunrise spot. So what they've done clearly is say, look, this thing may go against us. There's a real risk here, so we want to reduce the amount of capital to the minimum if we have to put up money to get this started. And They can change their mind any time and do nothing if they ultimately decide. They have a very loose agreement with the city. But their actions speak louder than words, and they are going after a very small investment. There are rumors that they are talking to the city about trying to do something in an old warehouse and have been negotiating with the city to do that, which would involve even less money. But the Phase 1 they're now proposing doesn't resemble in any way the plan that was originally presented, and that must be because they think there's huge risk here. And I said to you when I met you, when I was here last time, I'm not questioning Genting's financial resources, but that it was not rational in light of the risk that this binary decision that they can't have the land in trust, that a bank or Genting would want to risk a lot of money on that. And that's exactly what is happening, assuming they move forward with their drastically scaled down Phase 1. So they seem to be conceding that there's big risk. Anyone talks to about this land and trust issue, okay, will say, my God, how did they come up with this decision? We all know that the Department of Interior and the Bureau of Indian Affairs is trying to help Native Americans. We know that. But they have to do it within the law, and when you look at the language of the statute and referring to such members, which to me is clear as day, and anyone I've asked says the same thing, I don't see how this will stand up either at the lower court, the appellate court, or ultimately the Supreme Court. There's a huge risk, and that's why this project has been downsized dramatically because of this economic risk, assuming they move forward with Phase 1. Remember that they are not under your jurisdiction. They're here to talk to you about whether you should be issuing a license to us. If they decide they want to change it, it's between them and the city, and their contract with the city gives them enormous rights to do whatever they want. They can walk for a relatively nominal amount of money, and they have all sorts of provisions in their agreement. So I don't know what they'll do, but I do know that they are now proposing a drastically smaller project.
But doesn't that couldn't that also cut both ways in the sense that the flexibility that they have by building the most profitable piece of the project in a scaled-down version gives them, again, the opportunity to get cash flow up front, if you will. Couldn't that also be to some of their benefit?
Yes, sir. I think that there's a possibility that they might move forward. They said they would. I'm not questioning that necessarily, but I am saying that if they don't want to, they don't have to, and they're addressing you not as their regulator. When I address you, I'm addressing you as my potential regulator, and I'm regulated in other major states, New York, Illinois, Pennsylvania. I know that the chief made references of I have thick skin, that I may be lying. I don't lie, but I certainly won't be lying to my regulator, who I'm going to, if I get a license, be beholden to and be straightforward and truthful for the entire period that we're in business together. And that's the way I've conducted myself in New York, Pennsylvania, Illinois, the province of Ontario, et cetera, and I'm sure in your due diligence you've checked that out. And I have thick skin, they can say what they want about me, but I'm pointing out that you don't regulate these folks.
Understood.
But this is a massively scaled-down project, and it must be because of the concern that it may be overturned. They don't know when. Could be sooner rather than later.
Mr. Bloom, so you believe the risk is because of land and trust, not another casino 17 miles down the road?
Oh, I believe that I'm going to get to that in great detail. I believe in the numbers of the innovation group and others that we've presented to you, that they will have a significant reduction in their income if there's two but that the amount that they have proposed of their reduction versus ours makes no economic sense, and I'm going to spend a lot of time discussing that. We have an expert from the innovation group who's going to be doing that. But I want to make it clear, their income will go down if there's two, as will ours, but they will still be a profitable casino, even under our numbers, if there's two casinos.
All right. Why don't we take a quick break before we're going to go to the innovation group next.
Yeah.
So why don't we take a quick break? It's been almost 2 hours. We'll be back in 5 minutes or so. Let's reconvene our public meeting number 184, and we will return to Mr. Bloom's next presenter.
Thanks.
Thank you, Commission. Michael, the slides. Okay, great. Thank you. I'm going to take us from the laws of men and women to the laws of nature and gravity for a little while, and I hope to be brief, and we've made a concerted effort not to go into the large amount of detail that you've been presented previously on the modeling and on the numbers, but some very new succinct points today for the most part. So I was asked by our client, Mass Gaming, to evaluate as the focal point the December 2015 Spectrum competitive analysis, which was presented with the attorney's letter you received in anticipation of their last session. We have presented to you and delivered on Tuesday what we have called the Gaming Revenue and Tax Impact Analysis, Region C, Massachusetts. I would certainly not be surprised if there hasn't been time to fully absorb and interpret it, but the key points will be revealed in the presentation today, and you have the letter itself in the file, the report. And essentially, the Spectrum report, the Spectrum Gaming report that has been used to
Excuse
look
me,
at...
what was the date of that report?
It's December 2015.
Okay.
It didn't, I don't think it had a date on it, but I'll check for you in a moment. And the key aspects of that report by Spectrum look at scenarios largely with Taunton and Brockton operating in concert in the region, and then drill down to the effects on Taunton from having a new competitor in the region. And there are three areas, there are many areas that were covered, but they fall into three major categories, and I'll speak to those three categories today. First being the nature of the Spectrum forecast itself, so the financial forecast, the revenue forecast for the region. The second area will be about the examples that are used to back that revenue forecast, primarily tribal scenarios in other states. And the third area, which is very, very brief, touches on some economic impact implications. So the first slide that we have up is Spectrum's unsound forecast. The gaming revenue forecast offered by Spectrum is not credible. It defies the laws of gravity to award a lower market share to Brockton, which has a superior location. So if you look at the charts on this slide, they're very telling. On the left, we have a pie chart showing Spectrum's revenue forecast for Region C, with both properties operating. The two slices of the pie there on the left represent Taunton at $365 million in gravity model gaming revenue. On the right, Brockton, Spectrum's forecast for Brockton at $263 million of gravity model gaming revenue. And although the percentages are not there, Spectrum is essentially assigning a 58% market share to Taunton versus a 42% market share to Brockton. The gravity model, essentially in this case, is telling Spectrum, or its use of the gravity model is implying that the property that is farther away from the population base with less gravitational pull is going to pull further from the main population base. If you look to the right side of the slide are the innovation group numbers, which are consistent with the numbers that we've been using, which show the same dynamic, although with Taunton at $229 million of revenue, and Brockton at $304 million in revenue, gravity model revenue. Okay? And I would point out that a much more logical and plausible case would be the 57% market share that we are implying Brockton would absorb relative to a 43% market share in Taunton. Both a lot of revenue, both very viable, but proportionally counterintuitive to say that a farther property will this easily outperform a property closer to the population base.
Mr. Sol,
Yes.
in the case of the spectrum report, one cannot ascertain the size and scope of the property that they assigned to Taunton, correct?
To Taunton or to?
To Taunton.
Go ahead.
All the work we did, and I'm going to get to that in detail when he's done, with not just them, with other firms, assumed the original proposal, which was almost double the amount of gaming positions they are now proposing for Phase 1. And we never know whether any additional phases will ever get done.
Okay,
Okay?
all right. Let's come back to that then.
Yeah,
Please-
we'll
please
come back to
proceed.
that.
But we're assuming for these numbers that they have a large casino.
Yeah, it was planned as of the time that we did our last, it would have been commensurate with our November presentation in terms of their scope,
500 million or so.
500 million. Further is, they did not provide a Brockton-only scenario.
Sure.
So we've had to work around that a little bit. And just to reiterate, this is gravity model revenue. Spectrum had elected not to layer in what we've all now known out-of-market revenue, tourist-type revenue. They've said that it's essentially the same regardless of who's operating what where. We don't agree with that, but we had to have an apples-to-apples comparison. So it's all gravity model revenue.
Yeah, but the gravity model depends on the size of the property. That's
Yes.
one of the key inputs.
The size is a factor, the draw of the size, but it is also mitigated by 6 or, in some cases, 7 other weighting factors based on the quality, the operator, the brand,
Sure.
roadway conditions, access, things like that.
Yep.
But you're correct, the size is a starting point.
And just to make it clear, we are using, all of our numbers, we're assuming that they end up with the original proposal of 3,000 slots, 150 tables, 40 pokers, a major hotel, lots of retail. That's what they originally proposed. And all of these numbers are the numbers we've originally ran. We haven't assumed they're doing worse because they've downsized for Phase 1.
I would also point out that if you add those two pie charts together, the overall implication of the Region C revenue in total, under the Spectrum forecast is $628 million in gravity model revenue. On the right side, if you add the two pieces of the pie together, we're at $533 million. So we're actually using a more conservative overall forecast for Region C in the first place. And the next slide, slide 3, essentially just summarizes our conversation we just had. Access to the population is the primary force behind a casino's market potential. Marketing, spend, payout advantages, and yes, size of the property, positioning of the property can all counteract gravity as variables, but they are secondary to access from the population to a relatively similar property.
Can I just ask you, this is, as you know, I'm new to the game here, so to speak. Is the most significant variable in the gravity model physical proximity to population?
It is.
Does the gravity model in that case take into consideration the casino in Region A?
I'm sorry, the last part, does it take
It
into
takes
account?
into consideration Region A is fully up and operating at this point?
Yes.
A and B.
You may be getting to this, but there's a massive variable in the tax rates, or lack thereof, which is not typically in your situation, when you're doing a competitive analysis, you're usually comparing relatively similar regulatory environments to one another. How do you factor that in? How do you, or is this coming to you, Mr. Bloom?
We have factored that into our analysis, and they're going to
I'm
get
gonna
into
talk about
great detail about other
Okay, all
markets,
right.
et cetera.
I'll hit it kind of formally, but the simple answer is that extra income they have, there are a lot of different things they can do with it. The goal is always to bring as much as possible to profit. So you're balancing that against potentially spending more marketing, potentially buying business, which has no economic impact, by the way, per se. You can enhance your property and build extra capital, and you can make your financing package more attractive, but they're all nuances and noise compared to the big picture of getting people from a convenient location to a properly built, attractive casino. The next slide, which I've got up here, slide 4, and I'll explain what's in the bar graphs, but Spectrum's disproportionately high GGR forecast for Taunton overstates their gaming tax, and logically, in converse, the artificially low GGR estimate for Brockton understates gaming tax. So when we roll up the entire taxes to the Commonwealth, which you see in the bar chart to the right, under the Spectrum model, on the left side, we have a blue bar that is total state tax revenue under a Taunton-only scenario of $356 million. In Spectrum's opinion, or in their math, with Taunton and Brockton together, falling to $328 million. So almost a $30 million decrease, they're telling you, in what's coming into the Commonwealth's coffers under that scenario.
So that's gaming tax, that's not gaming revenue?
Correct. It's gaming tax for all the properties in the Commonwealth.
Oh.
All 3 weeks.
All three.
And I know it's a little confusing, but
Yeah.
the point, so on the right, when you use our numbers, which haven't changed for the purposes of this presentation, they're the numbers that we've been using, we actually show a $6 million increase in total revenue to the Commonwealth, tax revenue to the Commonwealth, with all of the properties up and running. So,
But this, just to clarify, this assumes all the other facilities in the Commonwealth, the Wind Project, MGM, as well as Plain Ridge
Plain Ridge.
already operating, and ourselves and
Taunton.
Taunton. And I reiterate, we did not downsize the Taunton operation for the smaller project. We assumed the old project.
I'm going to move to the next slide, the bottom line analysis. If the Spectrum forecast is to be believed, the Taunton Casino would be better off in scenario 2, with Taunton and Brockton operating. The Innovation Group estimates actually that EBITDA would be $15 million higher, profit, $15 million higher under the scenario with both properties operating. And I think this chart, which I'm going to try and describe very carefully, will answer some of your other questions about what to do with the extra fat, as it were, of paying a lower tax rate or a zero tax rate. In this chart, both of these columns seek to present a mini pro forma. You've seen detailed pro formas in all of the submittals, but a mini pro forma showing revenue and EBITDA for Taunton only. However, in scenario 1, it shows Taunton as if it were Taunton operating alone in Regency. Column 2, scenario 2, shows Taunton, but with the competition with Brockton. Okay? So the first thing I'll point out is they're only showing a 12% revenue difference as a result of us, or Mass Gaming, being open in the region. That's the $414.2 million relative to the $364.5 million. The second thing I would point out is one of the more important factors to think about, and the marketing budget. With found money in terms of tax relief, will they be able to spend more to market? And the answer is absolutely they will. But there are limits on what is logical in terms of what we call buying business in the industry. And for the Commonwealth's purposes, when a lot of that is done through free promotions and found money within the property, there's no economic impact associated with it. It's essentially just taking profit and giving it back to players to incentivize them to come down. It's not buying ads, it is basically buying business. If you look, you'll see we gave a 20% increase to that marketing budget that is consistent with what we have seen happen in similarly competitive situations. We haven't seen people doubling their marketing budget. We haven't seen people even raising it by 25 or 30%. It is tempered for a reason. You're still trying to maximize the bottom line. If we move to the next line item, other expenses, you'll see the other expenses actually go down. Each property is operating at a lower volume of revenue individually. Therefore, some of your expenses on a percentage basis and on a real basis change because you're serving less guests, you have less variable cost. Your fixed costs are the same, your variable costs will shift. And finally, on the net effect of these differences in marketing spend and other spend is about a 3.4% change in expense. So if you look at the final, second to last row, gaming tax, in scenario 2, we have obviously removed the gaming tax, which would no longer be in the equation, and we result in the comparison of profitability. So under scenario 1, with Taunton operating alone in the Region C, we're showing $175 million in EBITDA, or profit before taxes and depreciation and amortization. And on scenario 2, we're actually showing $190 million in EBITDA. So by Spectrum's own numbers, they actually show their client doing better with us operating in the market.
Can I ask a question there? So if this is the case,
Yeah.
shouldn't Spectrum be advising their client to let the commission issue a license?
Yes, and they don't believe these numbers. They're not believable, and I'm going to get into those in more detail, okay? They can't possibly believe that their business goes down 12% and our business goes down a massive amount if there's 2 casinos when we're 17 miles closer to the big population in Boston, okay? And I'm putting up my money, my grandchildren's money. I've been in the real estate business for 45 years picking locations. We've opened many casinos. They're all profitable. They don't believe. If we believed the Spectrum numbers, I wouldn't be here. Because they basically have said that we will be destroyed, they'll hardly be touched if you have 2 casinos. And they've done that to show that the Commonwealth makes less money because when our revenue goes down, we don't pay, we pay taxes at 25%, and so their numbers are not believable, the Spectrum numbers, and I'm going to get into that in much more detail when he's done.
Okay.
Okay, so
But you've asked the absolute correct questions, sir. It's the heart of my analysis that they can't believe these numbers.
So in summary for the first area, which is the forecast, and on slide 6, there are many reasons to doubt the consistency and the credibility of the Spectrum analysis. The analysis claims that Taunton can overcome the laws of gravity by buying customers. We believe this is a very dubious premise and a fundamentally flawed starting point for looking at what will happen on the waterfall below revenue. So I'm going to keep moving now into the second area, which is the examples. So all of these assumptions made in the Spectrum report hinge upon examples in 2 primary states, New York and Florida. In both cases, what Spectrum has set out to do is to say that tribes in those states with lower tax rates, as they believe they would be in Region C in Massachusetts, are outcompeting their commercial competitors because they have a lower tax rate, which seems logical on the face. But in fact, in each state, the dynamics at work are counter to that math, and I'm going to explain in 3 different areas. First of all, the analogous, or the analogy they're drawing between the commercial and tribal properties in the area of product and offering are very different. In Florida, they're trying to tell us that the Seminole tribe, because of a lower tax rate, an effective tax rate of 12%, relative to the parimutuel slot facility tax rate of 35%, is able to be so much more successful. But living in the middle of the state and having studied it and worked for both of those client groups, I can tell you that the key factors are about the size and scale and scope of the physical plant and the amenities and the existence of table games. Alone, the existence of table games in those properties, as you can see when you look at Twin River relative to, say, Plain Ridge, are a completely different offering. In New York State, we have a similar situation. The Seneca tribe, also a client of ours, has a full-scale offering. The Spectrum report is comparing that to highly taxed parimutuel properties, largely in the New York metro area, which have only slot machines and don't have table games. In terms of the locations themselves and proximity, we've got, in the Florida case, similar locations for parimutuel facilities and the Seminole properties. Most populants in South Florida can get to a property that's owned by the tribe or property that's in a parimutuel facility as easily as one another. So there's no distance factor as there is in Massachusetts. And finally, and importantly, incredibly, left out of the equation is the difference of smoking laws in each case. Spectrum fails to acknowledge that the slot facilities in Florida and New York are subject to smoking bans where the tribal casinos allow smoking, effectively giving them up to a 24 to 36% advantage over the smoke-free competitors. This omission in itself undermines, we believe, the entire discussion of Florida and New York. The smoking advantage, thankfully, will not apply in Regency. Both properties will be non-smoking.
Can I ask
And-
a question about that?
course.
Where does the 24 to 36 number, is that a number that you, the innovation group, conducted a study and came up with those numbers, or?
Yeah, the number is based on the impact and then the replacement of revenue to a smoking environment that we've measured since Delaware, the first state to outlaw smoking over, I think, 18 years ago. So we've measured it globally in the US and Asia, everywhere, and the range is about, the range of the impact directly on property is about 12 to 18%.
When was that study done?
Well, the Dover Downs study would have been, I'll have to look. I mean, it was literally more than 15 years ago.
Okay.
We also have benchmarking, though, much more current that we can present as an exhibit to the commission.
Thank you.
So before we leave the idea of the comparison between tribal and non-tribal properties, turning to slide 9, there's a more comparable example right here in Massachusetts. Twin River faces a huge tax advantage relative to the tribal casinos in Connecticut. That's 60% to 25% versus 25% on slots, okay? And on tables, 17% at Twin River versus 0 on table games for the Connecticut tribes. Despite this disadvantage, it competes very effectively, Twin Rivers, in the market. So just think about the distance differential and the difference between a 60% tax rate and a 25% tax rate and a 17% tax rate and a 0% tax rate. They're not able to defy the laws of gravity, even with those disadvantages in terms of people picking a more proximate full offering. And the third area really is about economic impacts. I have just a few things to say about it, but the only thing you'll notice covered in the Spectrum report, and I think it was for a reason, on economic impact differential, was paying lip service, which it had to, that you would have more direct jobs in the region with the second property. 1,800 more, 1,500 to 1,800 more. But they simply dismissed it as being only one factor, as if it is an unimportant factor. To us, it's the most important factor. But beyond that, they've also failed to talk about the spin-off effect, which you've heard about ad nauseum through this whole process, but the jobs on top of the direct operating jobs, the construction jobs, 2,000 construction jobs, and the nearly double the construction and operating jobs impacted in the spin-off effect of those jobs in the economy. So that's been ignored very simply in the analysis. And in our measurements, $30 million, $28 million actually, of non-gaming tax revenue spent at the amenities, the food and beverage, restaurants, hotel taxes that accrue to the Commonwealth from the second property in the region that they are silent on. And the $85 million of upfront payments being paid by Mass Gaming that would not be paid by the tribe. So to sum up economic impacts on slide 11, while cannibalization would reduce the economic impacts at an individual casino, sorry, I'm one ahead, Regency as a whole would see increased employment and increased purchases of goods and services by the casino. The casino resort GGR in Regency is estimated to increase by 60% by our measure, 52% by Spectrum's measure, in either case, which has to set off new impacts and their spin-off effect. And finally, the fiscal impacts from other sales of other non-gaming taxes, operations in Brockton are estimated to be over $28 million. And before Mr. Bloom goes into a little bit of the analysis that our competitors did for him, at other points in time, I'll just reiterate the three areas. Counterintuitive application of the gravity model by Spectrum, which is an inaccurate representation of the tax impacts on the Commonwealth. Secondly, irrelevant comparisons in Florida and New York, a better comparison here closer to home. And thirdly, significant additional economic impact as a result of another property. Very logical.
Okay. Chairman Crosby and members of the commission, thanks for giving me a chance to talk to you again. It's not the first time, but I am still struggling with pronouncing the name of the city of Taunton with my Midwest accent, and I apologize. I keep trying and I keep failing. So first, I want to start with giving you some additional reasons why the innovation numbers we believe are accurate and the Spectrum numbers don't make any sense. As part of our normal due diligence process before we decide to pursue a particular casino development at a particular location, we often obtain different expert opinions as to the projected revenues. As I've said, we invest our own capital. We're not a public company that has to make deals to grow. I'm investing my money, but I'm mainly doing this for my grandchildren, and we want to make sure we're right. And we don't want to lose money. So in this case, when we started looking at this site, okay, in addition to talking to innovation, we retained and in particular, what the impact would be on our earnings if there was also a facility up and running in Taunton. Importantly, we did this in December of 2014, shortly before we were introduced to the Brockton site, when I started looking at it with our team and met our partner, George Carney, who owned the site. So importantly, these studies were not done to present to you all. We were doing this to figure out whether we wanted to do this deal, okay? And we had another site or two that we were looking at, and we were comparing it, but we were nervous with the other sites that they were much closer to the Taunton site than Brockton, which had the advantage of being 17 miles away and closer to the population base. In addition, okay, we were talking to ClearVest, our potential partner, who was our partner in Des Plaines in Chicago, about another project that they had worked with us on. And So we invited them to look at this project with us because we felt some obligation to do so. And they, on their own, they're an investment firm with extensive experience, hired a third firm called Leisure Dynamics to do the same study in December of 2014 for them to decide whether they wanted to do this deal, whether it made economic sense. Okay? Maxim's numbers and Leisure all came in the same ballpark as the innovation numbers. And again, this was done in 2014. Maxim predicted 277 million of revenue for Brockton, and Leisure predicted 315 million. These were all, by the way, comparable gravity numbers that we're using. So, secondly, and this was the point made earlier, we were assuming that Taunton would have the much bigger facility that they had proposed then, not the smaller Phase 1 now. Okay? The average of all of these together, okay, is $304 million. Spectrum's, what we consider outlier number, was 263 million, as you've heard, which is less than 12%, which is 12% less than the average of all three projections that we've had that were much closer to one another. Most importantly, the average percentage drop for Brockton's gross revenue, if there's also a Taunton casino, based on the analysis of the three firms, was 19%. So everybody said if there's a casino in Taunton, on average, the three of us said it would be 19% drop in our revenue. Spectrum's analysis, okay, would have Brockton's revenue dropping 37% if they were competing in a casino in Taunton. Well, they said that Taunton's revenue dropped only 12%. I have to tell you, it makes no sense. We are 17 miles closer to Boston, and that's where the lion's share from South Boston and much more population is going to come from. And again, all of these assumed a much bigger casino. Further, to illustrate that our projections are not overly optimistic, the average of the three projections for Brockton alone, okay, was actually lower than Spectrum's projection for Taunton alone. And that's just not possible, because this, assuming none of the tax issues, okay, they're 17 miles away, further to the south, where there's far less population. And I think I said earlier, I've been in the real estate business a long time, okay? I've looked at all, I went to their site, I went to our site, I went with our people, and we're convinced that we have a much better site, and we're gonna do more business than they are, because we're right off Route 40, the route, and it's just gonna work. And again, these numbers all were done, the other two guys were all done with having nothing to do with any presentation. They were done back in 2014 to see if we wanted to do a deal. Now, the second point that I wanted to make, which has already been made by this distinguished commissioner, which is an absolutely logical conclusion. Our actions are supporting our belief in the innovation numbers. As I said before, if we believed in the Spectrum's low numbers for Brockton and high revenue numbers for Taunton when there are two casinos, I wouldn't be here. It wouldn't be a good investment for us. Conversely, if the tribe and Granting really believe the Spectrum numbers, as you said, sir, they should welcome a Brockton casino, since they'd make more money when they're paying a zero tax rate. Yet the opposite is true. They're opposing it as a practical matter. They must believe in the innovation numbers supported by the other firms. And let me give you a very simple example, because innovation went through marketing costs and everything else. But it's very simple. if you start out with $100, and they said, Spectrum, that they would lose 12%, so it's $12. So you'd lose $12 of income. But you don't pay 17% taxes on the $100, so you save 17, you're $5 ahead. So you've got more money to spend, but I don't know why they're out here trying to convince you otherwise not to give us a license. Their 12% drop in revenue is really so much lower than what they propose for us that it's astronomically, frankly, I think ridiculous. Using innovations numbers, which they used for us and what we relied on, Taunton would have a much larger drop in revenue, 31%, okay? And their EBITDA would drop by 40% on our numbers, okay? If there are two casinos. So that would be a significant hit to them, as it would be to us. A 40% drop in EBITDA rather than an increase. And that's why the tribe is opposing our casino. But it's important to note that we ran numbers using innovations numbers. So how much money would the tribe make? Because I have said before that the tribe, if there's two casinos, would still have a successful casino. And it would not be as successful as if there are the only one, of course. But they will still make, based upon our numbers, the innovation numbers, over $100 million of EBITDA. So they are not destroyed, but they wouldn't have a monopoly. There'd be two casinos. So the bottom line is, I don't believe the Spectrum numbers make any sense, and I don't believe that the Genting or the tribe believe them, or they wouldn't be here fighting us, because they would do just fine if you believe those numbers. So let's spend just 1 minute. I've already covered.
Excuse me, while you're on the EBITDA question, would you just say again, your numbers suggest that the difference, what is the drop in your EBITDA between your standalone and competing with Taunton?
Okay, for us?
For you.
For Taunton, it dropped about 40%.
Which is,
okay.
no, for Taunton drops 40%? I mean your EBITDA.
Okay, I was just saying, they
Okay.
drop about 40%.
Okay.
We will drop from about $130 or $40 million to somewhere around $100 million. I don't remember. So we drop also.
Okay, about something like 130 to 100.
Yeah, I don't remember. Do you have the exact number, Scott?
But if that's ballpark, then.
Yeah, it was the ballpark number. We were in that range, okay? And that's in the materials we sent to you. So we get hit, and they get hit. But their numbers were, they don't get hit at all. Well, they lose 12%, which is way less than any of our other assumptions, and they don't have to pay tax. So let me talk for a minute about their plans, which I have already spoken about. And first and foremost, let me say this. Under their new Phase 1, assuming that they actually do that, you end up with a facility that is nothing that was originally intended in the legislation or the Commonwealth. You were supposed to have a full-service casino resort, okay, to create jobs and economic development. And Phase 1 is a shadow of that. I don't know whether they'd ever have a Phase 2 and 3, et cetera. We're starting out with the full project. And as I said earlier, they've done that because, number one, they can do what they want. They're not under your jurisdiction. And number two, economically, they cannot take the chance that it'll ultimately be decided that they can't have a casino. So the bottom line is, and your ultimate decision is, what makes the most sense for the Commonwealth. That's your decision. So in conclusion, let me just say a couple of things, okay? And I don't want to repeat too much of what you've heard, but I think we can all agree that you have a right to issue a casino. You made that decision a long time ago. And I think it's totally clear, both that there's no prohibition on you doing so, and even if there was, the various timetables have already elapsed for you to do so. And there are many, many reasons why the land and trust decision is very questionable, particularly the carcieri language, regardless of which court has to look at this, okay? A new issue has been raised today by us about the compact. I think it just throws another area into question here. We were convinced of our position before we discovered this. We recently discovered it. I think when you look at the compact itself and you look at the sections of the act that they referred to, it's very clear that they did not meet their own condition precedent to that compact becoming effective. And as our attorney has pointed out, it's not a technical difference. There's a real legal distinction between effective by operation of the 45 days passing with nothing happening, or them actually giving a notice of approval in the Federal Register. And again, by the way, I've asked this of more than just one attorney, and I get, in gaming experience, it got the same reaction. But when you get right down to this, you know, you have to decide whether granting Brockton a license is in the best interest of the Commonwealth. And we think it clearly is. When you look at this situation, you basically have two choices. If you award us a license, you'll certainly have one casino, that's us, up and operating with all the whistles with it that we've said we're going to do. There's no phases. It's going to be a hotel, etc. And we have shown you that if we alone are the only casino, you're going to make $71 million per year more. Okay? In addition, this is going to be an enormous, enormous benefit to the city of Brockton that needs this money as much as anybody, for all the reasons you've heard from the mayor. And if you ultimately have two casinos, because it's ultimately determined that land may be in trust, okay? You're going to have two successful casinos that are both going to make in the area of $100 million, okay? And you're going to have twice as much jobs and twice as many economic improvements. And our numbers show that you'll make $6 million or $7 million a year more if you have two casinos than if you had Taunton alone. And I should point out that both the statute and the compact, which we now say isn't even effective, and it was in both compacts, okay, made it clear that there was an anticipation that there could be two casinos, a commercial and Taunton, in Region C. There were various provisions dealing with that, where they don't pay tax if that happened. Your other alternative is you don't issue a license to us. First, you put a stake in the heart of Brockton, all right? And that is a town, a city that really needs it. It's a large city in your Commonwealth. It's minority, majority, and they're in desperate need of economic development, and this is a perfect place to do it. We all know that the land and trust decision may be reversed, in which case you'll have no casino, you'll have no revenue, no jobs after that happens. And for sure, you know there's going to be litigation that's going to go on for a long period of time. So when I look at the risk and the possible pluses and minuses, you know, I must say, it seems to me that it's a much safer and surer bet to have two casinos. And our numbers, supported by 3 other firms, and our own money on the line, would indicate that if you have two casinos, we don't think you're going to have any kind of disaster, that this market is not oversaturated, and there's enough room for us to have reasonably successful casinos. We are both much better off economically if we're alone. That's obvious. Everyone would like to have a monopoly. But I think there's not much risk in giving us the casino, and you're taking a huge risk where you have no control over what the tribe and Genting are ultimately decide to do in light of the citizens' lawsuit and maybe other lawsuits. So you have to make the decision. You're intelligent people, and we hope and you will make what we think is the correct decision and the best in the interest of the Commonwealth. So that covers our comments. I believe the next person is the tribe's,
Yes,
the consul's lawyer.
Right. Yes, unless there are other questions
Yeah,
from
let's
Mr.
see if we
Bloom,
have
I-
any questions for Mr. Bloom. Anybody?
One question. Is it at least possible or feasible that if for the tribe to come in with what I might call a category killer, $1 billion, like they say, up front, emboldened by, let's say, what they now understand better, that it's in their interest to have another casino there because of the differential. I know it's very hard to predict their thinking or their actions after, especially, by you, but is that at least a possibility that would factor into some of the numbers that Spectrum comes up with a much bigger property, perhaps a much bigger gaming revenue?
Well, sir, we ran all our numbers assuming that they did their large casino, and our numbers are comparable. We're doing something very similar, our number of gaming positions, et cetera. But we assumed that they did the full casino with the hotel and everything else. But we picked this site and are prepared to invest up to $700 million, roughly, is our estimate, in our project because of our location. And we think we'll build a very nice project, and we'll do a good job of running it, and we're confident we can compete with their major casino. But my only point was that that's our assumption for all of our numbers. I wouldn't be here if I thought that we couldn't be successful. And as I said, our projections are that we would do somewhere around $100+ million in that range, or over, slightly over, if there are two. It just is, that's about what we thought they would do. Always, we think we'll do more business than that because of our location, but their facility won't be any nicer, we don't feel, than ours. In fact, we think ours will be better for the market. My point about their phase one was simply that we don't know if they'll ever get beyond phase one. And I think you had pointed out that, well, what if they run this thing during this period or something, make some money during this period, and it may well be what they're thinking if they do the smaller property, but that means that during this period we would have an even bigger advantage over them because we'd have a much nicer facility. So if this thing went on for a period of years, we would be doing better, and they wouldn't be paying taxes, and they'll do okay. They'll have a much smaller investment. Remember that when they talk about their investment, they're including all the money they've spent to date, okay, which has really nothing to do with the development of this project. They don't have the requirement that they spend a certain amount of money on their project under a statute like we do. The statute says we have to spend a certain amount of money on the real project. They don't have that. So they've spent, I don't know, but there are rumors they've spent a lot of money already, giving money to the tribe, et cetera. But in any event, we're convinced ours will be successful. Our project will be physically as nice as theirs. We don't develop inferior projects. We develop nice projects. We compete with all kinds of other operators, and we compete with non-smoking in displays in Indiana. And I can tell you the table games versus slots only is enormous difference. We opened our casino in Philadelphia with just slots. They hadn't changed, I meant in Pittsburgh, I'm sorry, with just slots. When we were able to put in tables, not only did we get table revenue increase, but our slots increased dramatically because you get companion people coming in. Let's say the man wants to play tables and his wife or girlfriend wants to play the slots, and our slot business ramped up tremendously, as of course we now had tables, because they changed the law to allow tables after we opened.
Thank you. Fair enough.
This is a little bit obscure, but as I think about how we're going to weigh out the rights and the equities and the economics on this, if you were awarded a commercial license and the tribe elected not to go forward with a casino, it would be worth somewhere in the neighborhood of $30 million a year to you in EBITDA. Would you consider mitigating, using some of that EBITDA to mitigate the loss to the tribe at least until a court case deprived them of the right to have a casino?
Well, we actually, under our agreement with the city of Brockton, pay the city of Brockton more because they have a percentage of our gross with a minimum. So the city of Brockton would get more, but we certainly weren't intending to subsidize the tribe.
I know you weren't intending to, but you pointed out that there's a $30 million benefit to you if they don't go forward. There's also obviously a loss to them if they don't go forward. And would you consider?
Well, they say they're going forward. They say they're starting phase one, and it would only be determined that it's not legal for them to go forward, that they shouldn't have had their land in trust, and that's a decision of the federal courts.
Right, but my question was, would you consider using some of that $30 million to mitigate the cost to them, the loss to them, if that circumstance transpired?
I guess I could consider it, but I certainly couldn't commit to it.
No, I understand
We
that.
certainly would be making more charitable contributions, as we always would do, as our property is more successful.
Okay. Anybody else?
Just a question of detail, Mr. Bloom. On the scaled-down size of the Taunton project, and it was described to us a couple of weeks ago that they're now going to do phase one, phase two, phase three. I have to say that I haven't drilled into the numbers, but are you representing to us that your review of their phase one plan results in a reduction on the order of 45%?
45% of gaming positions.
Of gaming positions?
Yes, and let me try to take you through it. They originally proposed, I think, their current proposal is 1,941 positions, I believe, and 60 tables. Tables usually count for 6 times each one. So if you add those together, their old proposal, I have all the exact numbers here, which was they had, yes, here it is. They had their original proposal, yes, right now it's 1,941 slots and 60 table games in one retail shop. Their proposal in 2012 was 3,000 slots, 150 table games. So that's times 6, so that's 39. 3,000 plus 900 for the table games, plus 40 poker tables, that's also 6, that's 240. So if you add that all together and compare that to the current, which is 1,941 slots and 60 table games, remember, multiply 6 times 60 for tables, you'll find out that they dropped the number of gaming positions by roughly 45%.
And that 19 and 60 tables number is their phase one?
Yes,
Remind me.
that's the current phase one they just
Current phase one.
presented to you. Okay.
The way that I understood it was that in Phase 1, they were going to basically build out the gaming floor, but not build out the hotel and
Part of the
some
gaming
other
floor.
thing. Huh?
Half the gaming floor.
I had thought it was the whole gaming floor, but
No,
it's not.
60, yeah, two-thirds.
Two-thirds of the gaming floor. Right. Okay.
But it's about 45%, 55% of the number of gaming positions.
Mhm.
And we're back to the point, why are they cutting it down? The market hasn't changed, it's because of the fear of the lawsuit.
Okay, next up.
Well, as noted, we're going to cede some of our time to Mr. Bond, and I'll move out so he can sit here and have a microphone.
I should point out that Mr. Bond represents the citizens group. He does not represent us, nor is he, speaking on our behalf.
Except that he's paid for by you.
We do contribute to the tribe to the citizens group, who in turn is paying his bills with our money, and they attempt to raise some of their own.
Right.
I don't know how much they've raised on their own. I'm not suggesting that.
No, I understand.
It's not, but we are part of it.
Right, okay.
Commissioners, my name is Adam Bond. I am an attorney in Middleborough representing the plaintiffs in the suit that was filed against the Department of the Interior concerning the record of decision taking land into trust for the Mashpee Wampanoag, a decision which violates the plain language of the IRA and directly contradicts the congressional intent of the IRA. One of the reasons to address the commission, is to try and clarify a few things, both historically and currently, that may be of some assistance to you. I've been involved with the Massachusetts gaming issues, the Indian gaming issues, and the Mashpee Wampanoag tribe for almost a decade. A lot of this that is going on currently had its genesis in January of 2007 when I was a selectman in Middleborough, and we tasked the town manager to see if the Mashpee Wampanoag tribe had any interest in siting a casino in Middleborough. At the time, I was not pro-casino or anti-casino. Like this commission, I was looking out for the best interests of Middleborough in the same way you folks are looking out for Region C, and you're looking out for the Commonwealth's interests. In researching the matter at the time, the law to me was unclear whether the Mashpee Wampanoag tribe would actually qualify for land into trust. This is all pre-Kashiri. But in discussions with the tribe, both publicly and privately, the tribe warned the Board of Selectmen that it was inevitable that land into trust would occur, and if there was no agreement, the town would get zero, nothing. So based on my analysis, I concluded that having an agreement for the town was the only real choice available in the decision tree. My decision tree was if the federal government followed the law and denied land into trust, then the town was safe because we had an agreement, but we just wasted time creating it. If the federal government made a jurisdictional grab and violated the law and granted land into trust, we would similarly be safe because we would have an intergovernmental agreement. I then shut my practice down for 1 week and participated in the negotiation of the first intergovernmental agreement between the Mashpee Wampanoag tribe and Middleborough, which I believe is the first one that was done in the state. When it was completed, there were a number of people that indicated that it was one of the most lucrative intergovernmental agreements in the country with very good protections for the town and its people with regard to expansion by the tribe and economics. On July 28th of that year, I was also involved in the largest town meeting in New England history, which was outside on a really hot day with a lot of people passing out, where they voted to approve that particular IGA. Now, I first dealt with the Mashpee Wampanoag Tribal Chairman Glenn Marshall, who throughout 07 and 08 continued to tell the people of Middleborough and myself that a casino would be built in 18 months. After Glenn Marshall was forced to step down as chairman in August of 07, I then began to deal with Mashpee Wampanoag Tribal Chairman Sean Hendricks, who in 08 or 09, in that time frame, also claimed a casino would be built in less than 2 years. After Sean Hendricks stepped down, I then dealt with the current chairman, Cedric Cromwell, who persistently told the Board of Selectmen that a casino was imminent in less than 2 years. In 2009, the U.S. Supreme Court decided the Kacheri case, which made it crystal clear that the Mashpee Wampanoag tribe, like the Narragansett tribe in Rhode Island, could not lawfully be granted land in the trust as they were not under federal jurisdiction in 1934. Very quickly after that, the Mashpee Wampanoag tribe picked up and pulled out to find a new location. They split with their backers, Wallman and Kersner, and moved on to different waters where they finally came to land in East Taunton. Due to my experience with the Mashpee Wampanoag tribe in Middleborough and my continued involvement in the Indian gaming laws and Massachusetts gaming issues, the current plaintiffs that are in this suit came to me and asked me for my assistance. I provided, on a pro bono basis, I provided them with interpretations of the severely discounted and watered-down IGA that got entered into in Taunton. Because that's when they came to me. They said, we have this IGA. We don't know what we're doing here. Can you help us sort of analyze it? Well, to an interesting point, which I think is relevant here, the Taunton IGA, when I looked at it, essentially what the tribal representatives did was take the Middleborough IGA, including the font and the formatting, went through it and stripped out significant money provisions and stripped out significant protective provisions that we had built into our agreement, and then essentially provided it to Taunton on a fill or kill basis, or a take it or leave it basis. And I was at a lot of these hearings where the take it or leave it was certainly amplified. But significant to this conversation, under the IGA with Taunton, the Mashpee Wampanoag tribe really have no obligation to Taunton to complete the project. The Mashpee Wampanoag can build a small piece and never get to the other pieces. And this was done through an expansive definition of force majeure. And for those of us that aren't lawyers, force majeure usually means act of God, tree falls on your house, somebody goes on strike, act of war, and terrorism. This force majeure includes the following as part of force majeure, quote, adverse economic events or circumstances which impact business generally. As a lawyer, which I am, I would have a difficulty being on the other side of this type of language, because it wouldn't really give much of an obligation. But this definition is so broad that it almost makes the Section 2 in the IGA, the duty to compete, an illusory promise, because all they've got to do is say, economically, we can't do it. But in any event, going back to the services I was providing for the plaintiffs, I spoke at many gatherings to explain the IGA provisions, I attended municipal hearings, and I raised many of the issues that are contained in the current complaint. I've been with these plaintiffs for years. I'm loyal to these plaintiffs, and we are in this fight together, regardless of the economics. I'm already committed to it. And this is, as Attorney Tennant said, this litigation is likely to go to the United States Supreme Court. So what's a little Middleborough lawyer doing going to the United States Supreme Court? Can I handle it? Well, I wasn't always in Middleborough. I spent the first 15 years of my career on Wall Street, working for firms such as Sherman & Sterling, Coudert Brothers, and my own partnership. And this case is not beyond my skills. I've appeared before the U.S. Supreme Court, and I did so in '97 in a case against the federal government, where an agency was attempting a similar jurisdictional grab. The alleged experts, when we picked up this case, lamented over Chevron deference and actually predicted that our claims would go to seed. Indeed, here, I believe at the March 15th hearing, Attorney Locklear relied on Chevron deference. I believe she said it at least 4 or 5 times during her presentation, and she was using that to write the epitaph of our suit. I note that she was also quoted in other papers as saying that this decision is not bulletproof, so there's somewhat of a dichotomy there. But despite Chevron deference, we reversed the agency's jurisdictional grab in a 9-0 decision from the United States Supreme Court. And in fact, Justice Scalia was so irritated by the government's misinterpretation of its own statute that he wrote a concurring opinion that he wasn't sure why this got to the U.S. Supreme Court, when the language of the agency and position of the agency was quote-unquote unnatural and in clear violation of the congressional intent. That's what he said. Having been to the U.S. Supreme Court on the merits in an analogous case, I can tell you with certainty that while Chevron deference is a factor to be considered, it is certainly not insurmountable. I'm living proof of that. And it certainly is not an absolute impediment to victory in this case. In short, I'm not abandoning my plaintiffs, and I have the knowledge and experience to win the case, which I believe will be governed by reading comprehension, not statutory interpretation, since the language in issue is plain and thus statutory interpretation is inappropriate. As to my plaintiffs, they're highly motivated to pursue their remedies. We have 20-plus plaintiffs. 20-plus plaintiffs, say that 10 times. With families and homes in the East Taunton area where the casinos to be built. These homes are the largest investment these plaintiffs have, and their future value now is in question with the LIT decision. The plaintiffs have a fairly rural way of life, and some have had it that way for generations. None of these plaintiffs have a desire to pull up stakes and move. In fact, some of them don't have the economic wherewithal to do so. The impact on these plaintiffs of the record of decision is that the character of East Taunton will be indelibly and forever changed without hope of reversal. And the plaintiffs will be living next to a sovereign enterprise in which they have no ability to control the impact of that enterprise on them through their own local representatives. Thus, the plaintiffs have an unwavering and ardent determination to protect their homes against federal overreach and will do so to the completion of the litigation process. These plaintiffs have actively been raising funds both before Mr. Bloom and continue to do so now and will continue to do so if Mr. Bloom leaves. Now, one of the really important things to address is Mr. Bloom and his people didn't come to us. We were hitting the phones. This record of decision came out. We had to do something to ramp this up. We went to them, and we asked them, and they were kind enough to give assistance. And in fact, it was Mr. Bloom's people who said they wanted that out front. They didn't want to hide it. They wanted it out front. Let the issue be there, whatever anybody wants to make of it. Unfortunately, some people have made the wrong issue out of it. And let me assure you, I am an attorney admitted in, I believe, currently 3 states, and all of them say the same thing. While I'm appreciative of the funding provided by Mass Gaming and Entertainment at our request, I am only beholden to my plaintiffs under the Code of Professional Responsibility of the state of Massachusetts. I'm beholden to them morally and legally. Whoever helps fund the suit is irrelevant when it comes to the client's interests. They have a goal. At the moment, maybe goals align. Tomorrow, maybe goals go different ways. So be it. My clients get their goals satisfied. I and the plaintiffs are involved in this matter to resolve our dispute with the federal government, and that's the other thing. I don't have a problem, neither do my plaintiffs, with sovereignty. We don't have a problem with land in the trust. Go right ahead, as long as you do so within the bounds of the law that Congress set out. Put it where you're allowed to, not where you're not. And that's what this suit is about. It's our federal government has done wrong by us, and we need to correct that. Finally, what happens between the Massachusetts Gaming Commission and the Brockton casino interests is between the Massachusetts Gaming Commission and the Brockton casino interests. Although we do understand quite cleanly and clearly that our current litigation, as well as any future litigations, are going to have an impact on what goes on in Regency in any decision, which is why I thank you very much for allowing me to address you and give you some insight into what's going on with the plaintiff's suit. Thank you.
Thank you. Thank you. Any questions? Is that it?
I said I didn't know what he was going to say.
All right, thank you.
In fact, this is the first time I think we've met.
Hello.
I might just ask Is it Mr. Bond?
Yes, sir.
Yeah, Mr. Bond, what is that case that you were referring to that was 9-0 with?
It was Dunn
Should
versus
just-
CFTC, which is the Commodity Futures Trading Commission was attempting to gain jurisdiction over off-exchange foreign currency trading. When they did so, they basically ignored the Treasury Amendment, which gave that jurisdiction to the SEC.
Okay, and were you involved in that?
I appeared with my partner. My partner argued. I watched him sweat bullets during that, but it was a wonderful experience. And we went all the way. I was involved in briefing and working on that project from soup all the way to nuts.
Maybe you could provide our staff with the site on it, because I'd
Absolutely.
be interested in reading it.
Fair enough. I will do so.
All right. Are you guys done? Do you have more?
No, that's it. We wanted to keep it brief.
All right.
And not rehash all the numbers that we presented to you in the past.
Anything else on this item from commissioners? All right, thank you very much for coming back.
Thank you.
Should we break
Yeah.
for lunch or
These other things, how long is yours?
maybe 15 minutes?
Mr. Chairman, I think they're both relatively quick.
Both relatively brief. Yeah, I think might as well plow through. Yeah. Good idea. Just gonna stand up too.
Okay. Everything's light. All right, we'll take 5 minutes.
All right, we are ready to reconvene meeting 184 at about 12:20. Next is item 3. The executive director, I believe, is passing the baton directly to Commissioner Zuniga.
Correct.
Thank you. Just wanted to provide the commission a little update on what I've found to be a very interesting and important part of my job as treasurer to understand and what goes on at the property in Plainridge relative to the information on the activity and the money, if you will, that gets collected. Commissioners might remember that there's 3 sources of important information here that are at play. We have a central monitoring system, as you know, that has been now in effect for a few weeks and operating, really well and satisfactorily. There's a house system that belongs to Penn that does a lot of the slots accounting. These 2 systems, the central monitoring system and the house system, are designed to be independent of each other. And then there's of course the cash that gets picked up, counted, and sent away, if you will, as the days progress. In an ideal world, all these systems need to be the same. What the information in any one of these needs to be the same. But there are discrepancies that happen from time to time, and part of the role that our revenue people under Derek, for example, and the role of others at IEB, the gaming agents, play in terms of understanding those discrepancies, explaining them, accounting for them, is critical. And it's very much a very important piece of what we do. So I wanted to give you, the big update is that those discrepancies have been decreasing significantly, all as part of the implementation of the central monitoring system, the refining of the internal controls, the procedures that we conduct, the procedures that we cause the casino to conduct. And perhaps more importantly, understanding those differences, when they come from, where they come from, and what to do to anticipate and account for is a critical piece of what we do. So I wanted to just give you an example. The update is that I'm very encouraged that these discrepancies are very small. When they are, they can be explained fully. They have also caused our team to have fine-tune our best practices, if you will. There's a couple of lessons learned. I'll speak to a couple, but it's something that I think is a great development. We have a full central monitoring system and its associated procedures really up and working. So I might be a little vague in terms of details because some of what happens in the role of in what we do dovetails into the own internal controls of the casino. And we've agreed that the details of the internal controls are subject to the confidentiality agreement that we have with the casino. But just wanted to give you a couple of examples as to where those discrepancies originate, just to give you up to date. So for example, the floor gets picked up at different times, not fully, right? The cash.
You've been in this business a while, Commissioner. You understand the lingo. For those who may not know what the floor being picked up means.
Yes. The cash gets picked from the boxes. The boxes, the slot machines have boxes that when they pick them up, they replace them by empty ones. But not every slot machine gets picked up every day. Let me just put it like that. And there's hours, certain hours when there's very low activity when that happens, and it doesn't happen right away. There's a team of people that goes from area to area. Now, sometimes the most simple of activity that needs to be accounted for is there's also another thing. The day ends, and this is a statutory end to the day, at 5:59 a.m. There's a statutory minute a.m.
12:59.
5:59.
5:59.
At 6 a.m. The day ends, and we collect a daily tax, et cetera, et cetera. So if the crews begin picking up the different boxes before and after that time for logistical reasons, and they don't pick up the entire floor for practical purposes, there needs to be an accounting of certain activity that might happen before something or after any one of these times. When, let's say, a slot machine gets picked up, the meter is read, the cash is now safeguarded, there could be somebody that comes in after the fact and plays that machine. That play needs to be accounted for in some form or fashion. Because on the accounting and corroboration with our central monitoring system, there's activity that has happened that, again, just needs to be accounted for. So there's timing differences that need to be, again, explained. There are, by way of other examples, there is a fair amount of change in location and denomination that happens in the gaming industry. I initially thought that once they set the floor, that's going to be there for a while. Not only do they change the denomination of certain games, they introduce new ones, decide to move them in proximity to other areas, et cetera. And that is really going to be going on quite a bit, to some regularity. When that happens, any of those moves need to be accounted for. And this is one of the lessons that we learned. In our central monitoring system, we've initially identified each of these assets by location, whereas a more robust and now identification is a special asset number, so that when the casino was moving one slot machine to another, there had to be an accounting for the activity that took place for this machine over here and the activity that then started from the same machine in a different location. You can imagine that if during all of that, the floor was being picked up in one area and not another, all of that again has to be accounted. I can answer questions if you want, but that's a big source of understanding discrepancies doing asset management, which is something that we have to do as part of our procedures.
Enrique, can I ask on that? Is the discrepancy, the scenario of the discrepancy that you're describing here and with reference to those slot machines and the day of, the official day end of 5:59, is it that the central monitoring system picks up the data at a different point in time, or somehow is not geographically parallel, geographically consistent with the house system that Plain Ridge is applying, or what?
Well, see, the central monitoring system reads the activity at all times. There's periods. There's a read into the meter that happens periodically, let's say, at all times. There's a difference in time, but let's not worry about that difference. What needs to be accounted for is if the system reads that the meter said something, the box gets picked up, and somebody in finance here or at the casino want to compare the cash to the activity, there may be some activity has already been picked up at, let's say, 4:34 in the morning,
right,
before the actual cutoff date.
Right.
All that there is this is perhaps what happens by the reality of knowing everything about the casino at all times. If we were auditing only, let's say, 10% of the activity, like we would do under a different over a manual system, a lot of these would be corrected by first looking at what's the cash and then testing procedures associated with it. Do you want to expand on any of that, Derek?
Yeah, so to get to the base of your question, what you're talking about is you've got a system-generated report that grabs meters from end of day to end of day, beginning of day to end of day, takes a variance between those and says, this is what should be sitting in the box. What Enrique is talking about is the slot drop process to grab 600 or 700 machines can't all happen at 5:59.
Right.
So their system does a combination between grabbing actuals of when the box was pulled so you can get the cash count on those meters to the boxes that weren't dropped, the machines that weren't dropped, estimates, and pulls those together. Our system is pulling all estimates end of day.
Right.
So what we've done for now until we can pull in, and this is part of our phase 2 development with the CMS, getting the actual meters at the time that the cash box is pulled or within a reasonable amount of time, I think a 3-minute window. What we're doing right now is taking a look at the end-of-day reports to end of day, figuring out what the estimate differences are, where the machines are that Enrique said we can take a look at. And once again, that's a limitation that we have to work within the system. Their system estimates what's on floor by drop location. So if you pull a machine that was in a spot that was supposed to be dropped one day and move it to a spot that wasn't supposed to be dropped the next day, you're going to have conflicting meter numbers there. So you have to kind of walk back the process. Where was this machine before? CMS is similar to that. However, what Enrique talked about is we're adding another field in that will be able to just track the actual asset so that we can keep the meters consistent and see what that asset should have generated for the day. So there are a lot of, a lot of fine points of trying to balance actual to estimates. And PPC even has problems when they pull their actual meter, what their estimated meters are for that actual cash count, where they have to pull back the slot variance, and they'll have their slots team investigate, was a ticket miscounted here, was there a counterfeit, was there money found inside the machine that shouldn't have been credited to it? So there are all kinds of different variances that go into it, but what we found is having the two systems to take a look side by side first and say, was there something that went wrong with the meters? Or is it something that physically the gaming agents have to go out and take a look at? Was there money left in a, has helped drastically.
That was going to be one of the other examples, that there's instances where, let's say a patron tries to cash out multiple tickets, and one of them gets stuck in the machine. And that patron, gets some cash, but doesn't, fully understand that, there was a short in terms of money, might end up leaving the kiosk or what have you. And until, but that differential, let's say a ticket stuck in the middle of the machine, is going to surface up as a discrepancy. And there's a separate procedure for that money. That money is not yet part of the gross gaming revenues. It has up to a year to be returned to the, to be claimed by a customer who lost it. So that's, again, back at where the procedures in terms of what we do overlap with other procedures, and that ticket, let's say, needs to be pulled out of the count and be placed in, remind me, what's the name?
Unclaimed tickets
Yeah.
or lost
right,
tickets.
or
Because
whatever
it
else.
never incremented a meter. So if you look at gross gaming revenue, once again, it's play minus win. So if it never made its way into there, and it's just sitting by the side, we're counting cash that was never played.
Derek, is the house system significantly more manually based than our system?
No, there are small differences in how it generates its reports. There are a few more manual things that they have to do as far as bypassing meters that our system catches. But you have to remember, our system is built just for gross gaming revenue. Their system is built for, our system tracks assets where it goes on the floor. Theirs is built for patrons. Theirs is built for all the different functions that
Customer
a
service.
casino
Marketing.
person on the floor would do, but not just that. You have the slot person who's overriding, you have manual jackpot payouts, you have error payouts that they have to process as manual, and all comes back to the accounting. So while they do have some limitation, it's built more for the day-to-day operations, and ours is built just mainly for tracking those meters. So we get a better read for that purpose.
And by the way, the system of record is the central monitoring system. If there's ever an unexplained discrepancy, the tax is based on what our system says. And there's a process for a monthly reconciliation that, and even before that, where PPC can say, here's what happened with this discrepancy, et cetera. We can issue a credit, if you will. But, the convergence of those two systems has been, very good in terms of understanding there's real redundancy here on a system that we feel is working really well, the CMS.
Is there anything, as you've gone through this process, does anything trouble you? Do you see any, your net, I gather, is that this is working pretty well, you feel good about it, but do you see any system weakness, institutional weakness, personal weakness? Is there anything that troubles you?
No, I think learning, having the in-house knowledge here, which we've done, part of me understanding this is wanting to know what's under that black box, if you will, at a high level. We have not just Derek, but a number of people under him that understand the reports that can be generated, that understand how to read them, how to reconcile them from risk mitigation standpoint, it's important that we have that capability here, that we continuously learn lessons as to how we prepare additional properties. I'm still very looking forward to how there's going to be a whole new procedure, if you will, associated with this relative to table games, because there's no such thing as a wire that goes and reads meters. There are systems that rate players, as I understand them, and understand and approximate the level of activity that a player brings to each one of the tables. But setting up and refining and building up procedures around that is going to be something, the next phase, if you will. I think the central monitoring system story is a very good one in the sense of how we have now taken what capabilities are out there and fine-tune them to, again, explain the differences that come from time to time.
Anybody else? Thank you, Commissioner.
Thank you.
Director.
Thank you.
Next is item 4, our Director of Workforce Supplier and Diversity Development. Director Griffin. Good afternoon.
Good afternoon.
Oh, yeah. That's better, right. I'm here to update you on a new opportunity that the Commission has released a request for responses in order to optimize the outcomes for the diversity goals that are outlined in the expanded gaming law, related to, specifically to the contracting goals of the casino. We are entertaining proposals that focus on planning grants or grants for the expansion of business technical assistance programs that can demonstrate that they are focusing on one of the targeted areas of the diversity programs. And we are considering awarding grants totaling up to $100,000 total statewide, and dedicating $20,000 of that for smaller grassroots and innovative or promising programs.
Is that $100,000 total?
It is total
So
statewide.
That's
So-
not a lid on a particular grant.
So it is funding intended to supplement existing programs mostly. It probably isn't enough to create a new program. But it is likely enough to, for a planning grant, if you are thinking about establishing a program. So Massachusetts-based not-for-profit organizations, public or quasi-public entities are eligible. And we have added a second bidders conference on March 29th here in this very same room at 2 o'clock. So if there are entities that are interested in want to come, or we will have remote access as well for those from the western part of the state.
You had one in on the 21st?
Yes, and that snowstorm,
Oh,
we
Nobody
just don't have
came.
it. It wasn't much snow, but it was enough to keep people, I guess, from attending, so. Although we have had expressions of interest. So responses are due April 13th, which is a Wednesday. All right. So I just wanted to update you on that new development and also update the public.
in your mind's eye, do you have a sense of how many you would like to award? I mean, do you have a sort of a sense of what the magnitude of these would be?
Chairman Crosby, I think it depends on the type of organization that applies and the size. I'll give you an idea that one area that we have found, we haven't found many organizations that specifically focus on veteran-owned businesses. And so that's potentially an area where an organization that does work with veteran businesses or works with other businesses that could potentially focus on that area. So just an idea.
Is it possible that some of these technical assistance may be eventually used for helping small business, let's say, navigate and comply with the licensing process?
That could very well be part of the proposal, and I would think very helpful to businesses.
Because I would love for us to see what we could do internally before we got to that point in terms of simplification, explaining, educating our own licensing process. I know there is only so much, time that we have, but I think there's more
Right.
effect, more if we could concentrate on this type of processes that we set up for, for the likes of small, diverse businesses.
Absolutely.
Anybody else?
Yeah, Joe, could you just, I have a little difficulty kind of making concrete what's being described here. Could you describe a scenario of a type of organization that would come to compete for these grants, and what type of services would they be looking to provide, or whatever? Just
So potentially a chamber, we have nonprofits across the state that focus on supporting small businesses with technical assistance ranging from helping them establish joint ventures to work with to expand their capacity to work with large organizations, to providing financing, and maybe helping them with getting them prepared for financing so that they can obtain a loan to expand their capacity to work with a large contract. So those types of organizations exist, and we've worked with many of them and are in communication with many of those types of organizations.
it strikes me that $100,000 won't go very far. So
Exactly.
you basically anticipating that we're talking about maybe $2,500, $3,000, which would provide, funds to hire, a specialist for a certain number of hours to be able to address licensing procedures or accounting
Right, so
conventions or whatever.
that's it, exactly. A couple of grants, or even, 4 different grants or whatever, it probably isn't enough to establish a new program, but it could be enough, for example, to hire specialists in certain topical areas that might supplement an existing program,
Right.
just
This-
as you suggested.
Okay.
This is similar to the attempt we made in the Plainville area, right? To get people, and we actually got nobody to come forward.
Well, actually, we did have a chamber, we had to put the RFP out twice, but we did have a chamber that offered technical assistance
Oh, you
and,
did? Oh, good, I didn't
and
remember that.
programs, yeah.
Good, okay.
One of the conversations Jill and I had when thinking about this program is, I've always suggested that Jill and Paul and licensing be attached somewhat at the hip as they're going out talking to business and explaining the licensing process. We had a visit the other day with a local Boston company who we were able to demystify some of the licensing parameters for him. But also tying into all this will be bringing our licensees to the table so that we're conveying the right expectations from our licensees to these businesses as part of the capacity building of these, obviously smaller, more diverse-owned businesses.
Anything else? All set?
Great, thank you.
All right.
Thank you.
Any other business? Do I have a motion to adjourn?
So moved.
All in favor?
Aye.
Ayes have it unanimously. Thank you all.
Well timed.